Establishment. The Bar Council of India, BCI, was established under a legislation enacted by the Parliament, namely, the Advocates Act, 1961. Hence, it is a statutory, and not a constitutional, body. In 1951, the Government of India appointed an All India Bar Committee under the chairmanship of Justice S.R. Das of the Supreme Court. The mandate of the committee was to examine and report on the issue of reorganization of the bar and legal profession in the country. The committee submitted its report in 1953. It recommended, inter alia, the establishment of an All India Bar Council and State Bar Councils, SBCs, to regulate legal profession at the national and state level. Later, in 1958, the Law Commission of India, again repeated and endorsed the above recommendation of the Das Committee. Consequently, the Advocates Act, 1961 was passed by the Parliament to provide for, inter alia, the creation of the BCI and SBCs. The BCI is an autonomous body. It works under the Department of Legal Affairs of the Union Ministry of Law and Justice. 14th Report on the subject of reform of judicial administration. The Union Ministry of Law and Justice comprises of three departments, namely, the Department of Legal Affairs, the Department of Justice, and the Legislative Department. O Bar Council of India. Composition _ The BCI consists of the elected members as well as the ex officio members. They are as follows: 1. One member elected by each SBC from amongst its members. 2. The Attorney General of India and the Solicitor General of India are the ex officio members. The BCI shall have a chairman and a vice chairman. They are elected by the council from amongst its members. They hold office for a period of 2 years. The term of office of a member of the BCI, elected by a SBC, shall be for the period for which she holds office as a member of that SBC. The BCI consists of the following committees: I. Disciplinary Committee, 1 or more; E. Legal Aid Committee, 1 or more; E. Executive Committee, IV. Legal Education Committee, V. Other committees, if necessary. Function 7. The functions of the BCI are as follows: 1. To lay down standards of professional conduct and etiquette for advocates. 2. To lay down the procedure to be followed by its disciplinary committee and the disciplinary committee of each SBC. 3. To safeguard the rights, privileges, and interests of advocates. To promote and support law reform. 5. To deal with and dispose of any matter which is referred to it by a SBC. 6. To exercise general supervision and control over SBCs. 7. To promote legal education and to lay down standards of legal education in consultation with the universities in India imparting legal education and the SBCs. 8. To recognize universities whose degree in law shall be a qualification for enrollment as an advocate and for that purpose to visit and inspect universities. The BCI can also cause the SBCs to visit and inspect universities in accordance with the directions issued by it. 9. To conduct seminars and organize talks on legal topics by eminent jurists and publish journals and papers of legal interest. 10. To organize legal aid to the poor people. 11. To recognize, on a reciprocal basis, foreign qualifications in law obtained outside India for the purpose of admission as an advocate under this Act. 12. To manage and invest its funds. 13. To provide for the election of its members. 14. To perform all other functions conferred on it under this Act. 15. To do all other things necessary for discharging the above functions. The BCI may establish funds for the following purposes. A. Giving financial assistance to organize welfare schemes for indigent, disabled or other advocates. B. Giving legal aid or advice. C. Establishing law libraries. Further, the BCI may also receive grants, donations, gifts, and benefactions for the above purposes. The BCI can become a member of international legal bodies such as the International Bar Association or the International Legal Aid Association. Establishment. The Advocates Act, 1961 provides for the establishment of a SBC for each state or a common SBC for 2 or more states or for a state and a union territory. At present, there are 24 SBCs. The name and the jurisdiction of all the 24 SBCs are mentioned in Table 69.1. 2. Composition. Any state bar council consists of the elected members as well as the ex officio members. This is explained below. 1. In the case of a SBC with an electorate of 5,015 members. In the case of a SBC with an electorate of 5 to 10,020 members. and in the case of SBC with an electorate of more than 10,025 members. They are elected in accordance with the system of proportional representation by means of the single transferable vote from amongst advocates on the electoral roll of the SBC. But, one half of such elected members shall be persons who have for 10 years been advocates on a state roll. 2. In case of any SBC, the Advocate General of the state is the ex officio member. Similarly, in case of a common SBC, the Advocate General of each of the states is the ex officio member. Further, in case of the SBC of Delhi, the Additional Solicitor General of India is the ex officio member. Each SBC shall have a chairman and a vice chairman. They are elected by the council amongst its members. The term of office of an elected member of any SBC is 5 years. But, if any SBC fails to provide for the election of its members before the expiry of said term, then the BCI may extend the said term for a period of 6 months. A State Bar Council consists of the following committees. 1. Disciplinary Committee, 1 or more. E. Legal Aid Committee, 1 or more. E. Executive Committee. IV. Enrollment Committee. V. Other committees, if necessary. 3. Functions. The functions of a State Bar Council are as follows. 1. To admit persons as advocates on its roll. 2. To prepare and maintain such roll. 3. To entertain and determine cases of misconduct against advocates on its roll. 4. To safeguard the rights, privileges, and interests of advocates on its roll. 5. To promote the growth of bar associations for the purposes of effective implementation of the welfare schemes for the indigent, disabled, or other advocates. 6. To promote and support law reform. 7. To conduct seminars and organize talks on legal topics by eminent jurists and publish journals and papers of legal interest. 8. To organize legal aid to the poor. 9. To manage and invest its funds. 10. To provide for the election of its members. 11. To visit and inspect universities in accordance with the directions issued by the BCI. 12. To perform all other functions conferred on it under this Act. 13. To do all other things necessary for discharging the above functions. A SBC may establish funds for the following purposes. A. Giving financial assistance to organize welfare schemes for the indigent, disabled, or other advocates. B. Giving legal aid or advice. C. Establishing law libraries. Further, a SBC may also receive grants, donations, gifts and benefactions for the above purposes. Types of advocates. The Advocates Act, 1961 provides for 2 categories of advocates, viz. Senior advocates and other advocates, who are entitled to practice law before the courts. The exercise of powers vested in the Supreme Court and the High Courts to designate an advocate as a senior advocate is circumscribed by the requirement of due satisfaction that the advocate concerned fulfills the qualifications prescribed under the Advocates Act, 1961. In terms of the Advocates Act, 1961, an advocate may, with his/her consent, be designated as senior advocate if the Supreme Court or a High Court is of opinion that by virtue of his/her ability standing at the bar or special knowledge or experience in law, she is deserving of such distinction. There are 3 categories of advocates who are entitled to practice law before the Supreme Court. These are explained as follows. Senior advocate. A. Senior advocate means any advocate so designated under the Advocates Act, 1961, and all such advocates whose names were borne on the roll of the senior advocates of the court immediately before the commencement of the Advocates Act, 1961. The Supreme Court Rules, 2013, deals with designation of advocates as senior advocates. These rules provide that the Chief Justice of India and the judges may, with the consent of the advocate, designate an advocate as senior advocate, if in their opinion, by virtue of his/her ability, standing at the bar or special knowledge or experience in law, the said advocate is deserving of such distinction. Apart from the designation of advocates as senior advocates, retired Chief Justices, judges of the High Courts are also considered for designation as senior advocates in the Supreme Court. A senior advocate is. To Indian Judiciary, Annual Report 2021-22, The Supreme Court of India, pp. 107-109. Not entitled to appear in the Supreme Court without an advocate on record. A permanent committee has been constituted by the Chief Justice of India to deal with all matters relating to designation of senior advocates in the Supreme Court. The composition of the committee is as under: a Chief Justice of India chairperson. B. 2 senior most judges of the Supreme Court members. C. Attorney General for India member. And D. A member of the bar is nominated by the chairperson and members of this committee. 2. Advocate on record. An advocate on record means an advocate who is entitled under the Supreme Court rules 2013 to act as well as to plead for a party in the Supreme Court. No advocate other than an advocate on record is entitled to file an appearance or act for a party in the Supreme Court. The Supreme Court at the time of its inception in 1950 inherited the jurisdiction of the Federal Court and the Privy Council. The rules prevalent in the Federal Court were continued in the beginning. The practice and procedure of the Supreme Court has undergone enormous changes ever since. Originally, the rules of the Supreme Court, as then adopted, recognized the system of agents. The practice and procedure was substantially modified in the year 1954 and advocates on record replaced the system of agents. When introduced in 1954, apart from the then registered agents, an advocate of 7 years standing was entitled to get herself registered as an advocate on record, provided she fulfilled the conditions prescribed. In 1959, the rules were amended, introducing the advocate on record examination conducted by the Supreme Court. The Registrar of the Supreme Court conducts advocate on record examination periodically with approval of the examination committee and under the supervision of Secretary, Board of Examiners, appointed by the Chief Justice of India. The examination maintains high standards to ensure that best of the talent come in as advocate on record. A regulation pertaining to the examination states that no advocate shall be eligible to appear in the examination unless she has received training from an advocate on record of not less than 10 years standing for a continuous period of 1 year commencing from the end of the 4th year of date of her enrollment. 3. Other advocates. These are advocates whose names are entered on the roll of any state bar council maintained under the Advocates Act, 1961. They cannot appear, plead and address the court in any matter on behalf of a party in the Supreme Court unless instructed by an advocate on record or permitted by the court.